All right, let's just dive right in. We all tend to think of a courtroom as a place where every single fact, every piece of evidence gets laid out on the table to find the truth, right? But what if I told you that sometimes a judge will look at a perfectly relevant piece of evidence and then tell the jury they're not allowed to see it? It sounds completely backwards, but it's an absolutely critical part of how our justice system is designed to work. So that brings us to the big question. Why on earth would a court, a place whose entire job is to weigh the facts, deliberately choose to ignore some of them? It seems to fly in the face of everything we think of as justice. But as we're about to see, this isn't a bug in the system, it's a feature. And it's a feature designed to protect something just as important as the truth itself: fairness. And this leads us to what you could pretty much call the evidence paradox. Believe it or not, this isn't a new problem. For centuries, the sharpest legal minds have been wrestling with this fundamental tension. How do you make sure the rules of evidence are applied fairly without just giving one person, the judge, way too much power? And this fear is nothing new. Just listen to this quote from all the way back in 1790. Justice Gross is basically saying, look, I'm terrified of a system where judges can just wing it. He wanted clear black and white rules that everyone, him included, had to follow. No exceptions. It just perfectly captures this deep historical anxiety about letting a judge's personal judgment get in the way of the law. Well, despite that fear, the legal world eventually came up with a solution. And it's this powerful tool called judicial discretion. It gives judges the ability to navigate these really tricky situations. But discretion, that's one of those slippery words, isn't it? It can mean a lot of different things. So to really get what's going on, we need to nail down exactly what it means in this context. So let's do that. Let's break down what this power actually is. Because judicial discretion isn't just a judge having a hunch or going with their gut. No, it's a very specific and carefully defined legal authority. You see, the law actually makes a distinction between two types of discretion. On one hand, you have a situation where a rule is kind of vague, and the judge's job is just to figure out the facts and then apply that rule. Once the facts are clear, they must act a certain way. But what we're talking about here is the other kind, a true freedom to choose. This is where, even after all the facts are decided, the judge genuinely has the power to make a call. In this case, whether to let evidence in or keep it out. But, and this is crucial, this freedom comes with a golden rule. A judge can use their discretion to exclude evidence that might otherwise be perfectly fine to admit, but they can never use that same discretion to admit evidence that the rules already say is inadmissible. The best way to think about it is that it's a shield, not a sword. It's a power that's only there to protect the fairness of the trial. Okay, so if a judge has this power, how do they decide when to actually use it? Well, it all comes down to a balancing act. I mean, literally, picture the scales of justice. On one side, you have how valuable a piece of evidence is, and on the other, you have the potential harm it could do if it's misused. So that first side of the scale is what lawyers call probative value. It's a fancy-sounding term for a really simple idea. How good is this evidence at actually proving a key fact in the case? Is it a smoking gun, or is it just a tiny, insignificant detail? The higher its probative value, the more weight it carries on that scale. Now, the other side of the scale is its prejudicial effect. And listen, this is a really important distinction. Prejudice here doesn't just mean the evidence hurts one side's case. I mean, of course it does. That's the point of good evidence. No, it refers to the very specific danger that the jury might react to it emotionally or irrationally. Will it just make them angry? Will it distract them from the real issues? Will they give it way more importance than it logically deserves? That's the danger the judge is trying to weigh. Now, this balancing act isn't just some vague idea floating around a judge's head. It's actually been written into law. Modern evidence acts have laid out very specific rules that tell judges exactly how and when to do this balancing act. Sometimes they give them a choice, and sometimes they give them a direct command. The Uniform Evidence Acts give us two perfect examples. First, look at Section 135. It says the court may refuse to admit evidence if its probative value is substantially outweighed by its prejudicial danger. The key words there are may and substantially. It's a choice, a discretionary power. But then you look at Section 137, which applies in criminal trials. It says the court must refuse to admit prosecution evidence if its probative value is simply outweighed. Not substantially, just outweighed. See the difference? May becomes must. The power turns from a choice into a mandatory duty. So, why the much tougher rule in Section 137? Well, it's all about who the evidence is coming from and who it's being used against. This mandatory rule only applies to evidence the prosecution wants to use against a defendant. It's a very deliberate, extra layer of protection built right into the system to safeguard the accused, because the stakes, someone's liberty, are just so incredibly high. So let's pull this all together. We've kind of journeyed from a centuries-old legal puzzle all the way to the very specific rules that govern a modern courtroom. And we've seen that when a judge ignores evidence, it's not about hiding the truth. It's about upholding their duty to make sure the trial is fair for everyone involved. So what are the big takeaways here? First, judges can and sometimes must exclude even relevant evidence to keep a trial fair. Second, how they do it is by carefully balancing how useful the evidence is against its potential to create an unfair bias. And finally, remember that in criminal cases, the system has stronger, mandatory safeguards to protect the accused from any evidence that's ultimately more dangerous than it is helpful.
And that really leaves us with one final big question to think about. When you boil it all down, what's the ultimate purpose of a trial? Is it to uncover every last fact no matter what? Or is it to make sure that the process itself, the fight, is fundamentally fair? The law of evidence seems to suggest the answer isn't so simple, and that sometimes fairness has to win. Thanks for watching The Explainer.